Lightning like Steve McQueen. I'm in the fast lane when the light turns green. And I built tough, I ain't nothing but grit. Cause I made rugged blood, sweat, and spit. Yeah, like a horse I fly. Better push yourself in for a bumpy ride. I like to play hard, but I work harder. And I weather the storm cause I'm built stronger.
What is up, ladies and gentlemen? We are back. We are live. It is the Freight Coach Morning Show, the top morning show in transportation, coming to you guys every single weekday, 8:30 a.m. Pacific, 10:30 Central, to break down some industry headlines and, most importantly, provide some actual insight into what you can do with all of this information. If this is your first time tuning in, welcome. This is the real side of freight, ladies and gentlemen. And I say that before every single show. And what I mean by that is I only speak to transportation professionals on this show, as well as my twice-a-week long-form podcast, because I want to talk to the right individuals who have done what you're looking to do or who are currently doing what you're trying to achieve. So you can take that information, apply it, utilize it, and see a meaningful difference in your business and your life. Happy Tuesday, everybody. Nick, my man, let's go. He says over there on LinkedIn. Yeah, you guys, we're just going to jump right in. We're going to talk about non-competes. Are they truly unenforceable now? What's actually going on? There's a lot of hype that you see all over social media. And when any of these things like to, start to come out, I like to wait a couple of days before I talk about it because I don't want to be first. I want to have the facts. And there is no better individual to talk to than our favorite attorney, Mr. Matthew Leffler. What's up, brother?
Freight Coach, it is great to be here. The FTC won't let non-competes be, so it's time to talk to the armchair attorney. Good to see you, my friend.
The FTC will not let the non-competes be. What? So what's actually going on with this? Because it's like as soon as that broke, it was, everybody out there had to put their opinion immediately, right? Because they all got to be first. They don't want to see the facts, but what are the actual facts of what was ruled out? Was this codified into law, or is this just hey, the president's going to potentially look at this at some point if it, nudges his poll numbers in the right direction?
Yeah, this is a great question. So the way to begin looking at this was January of 2023. The Federal Trade Commission put out a proposed rule that would effectively ban all non-competes in the United States. This would approximately invalidate over 30 million contracts. There's 1 in 5 American workers have a non-competition agreement. It's not just freight and sales. It's medical. It's every basic industry out there. And the FTC ended up having a comment period. And during this comment period, over 26,000 individuals and businesses filed comments about the non-compete ban. A year passes, nothing happens. And then in end of April, the FTC puts out what becomes the final rule. And the final rule bans non-competes in virtually every context, except for the sale of a business. And they have a couple carve-outs for folks that are making over $151,000 that are kind of like decision makers. So think like C-suite folks. The thing that happens here is once the rule is finalized, it must be published in the Federal Register for 120 days. After that 120 days takes place, then the non-competes would all be banned. The reality is far more complicated. What has happened the day after the final rule was issued, the U.S. Chamber of Commerce and other institutions filed lawsuits to try to enjoin it or to freeze it, pause it, and kind of challenge the FTC's authority to make the rule. So as of right now, there is no ban on non-competes. After the 120 days happens, there could be a ban unless it gets stopped in these federal actions that are kind of popping up all over the country.
See, again, this is why I wait a couple of days, because if you just took everybody's surface level information a couple of days ago when this all kind of came out, it was, non-competes are done. They're unenforceable, everything else. And I know that there's some states out there where non-competes have been banned for a long time now at this point.
That's right.
Essentially, this is just the graduation of the federal level at this point. And because they've already been banned in certain states, like the state of Minnesota comes to mind right away for me as well.
State of California, Texas has restrictions. Many states have come up and put restrictions in place on these non-competes. For the folks who are listening, let me just kind of explain a little bit about what a non-compete is. A non-compete is a type of post-employment restrictive covenant. It's a contract that you enter into with your employer that essentially limits your ability to do your job after you leave the business. business. So if you're a freight broker today with a company and you leave that company and you have a non-compete, you can't go broker freight for a competitor company or start your own business. These non-competes must serve a legitimate business interest. So they have to be kind of narrow in terms of what job you can't do, what the geographic region is that you're banned from, and then also the time, like how long, is it 3 months? Is it 2 years, whatever. And so non-competes are just a one of many types of contracts that kind of take away rights from workers and then give them to the company. And we've seen states make action, but the fact that the FTC has come out so hard on these things and really pushed the idea that we see wages are reduced when non-competes are involved. We see innovation gets restricted when non-competes are involved. The question really becomes like, does the FTC have the authority? And that's the litigation that's happening right now in Texas. And we'll find that out probably in June or July. But this ban, even if it doesn't end up working, is incredibly valuable for all Americans to understand, because this is not some esoteric thing. This is your brother, your sister, your children, your cousins, your aunts, your uncles. Everybody has a non-compete. And so it's important for us to understand really what's being talked about and what the issues really ultimately look like at the end of the day.
I think that, okay, so what stops them from everybody like agreeing, hey, you know what? Yeah, non-competes, they're outdated. They suck as long as you don't have access to proprietary information, which I stated on the show when that came out. Like, listen, if you have equity in a business or if you have proprietary information on like M&A strategy, product release, you should be bound to a non-compete, because that is extremely detrimental. And I know that that's what it's all saying out there. Go ahead.
To push back a little bit. It's like we have contracts that exist to do what you've described. So if I want to protect intellectual property and trade secrets, I have a non-disclosure agreement. That's a contract that says you can't disclose things that you learn that are confidential and proprietary. If I don't want you to call on our customers or call on our current employees, I have a contract that's called the non-solicitation agreement. What we have seen happen in the business is people are trying to say non-competes serve a function to protect confidential proprietary information. That is absolutely bogus. That is a disingenuous argument, because they truly know that those contracts already exist. Non-competes are all about saying you can't compete with me. I am such a fragile business that if you were to leave, you could presumably take everything from me. And so this argument about access to confidential proprietary stuff I don't buy it. Now, for senior level folks, like C-suite folks, non-competes still make a lot of sense. And those people will be bound by them if this rule ends up happening. And then same with sale of a business. You don't sell a business and not have a non-compete. You will have a non-compete when you sell a company.
Yeah, no, absolutely. And I just wanted to clarify that, because I think there's a lot of people out there who are leading a charge per se for the no non-competes, but they have an extremely stringent non-solicit that could be argued as a non-compete in a sense, right? Like, it's not as literal terms. And, you brought up non-disclosure agreements. How can you actually enforce a non-disclosure? How can you actually prove that the individual violated that outside of them writing a fucking email saying, hey, this was their entire strategy?
Yeah, I mean, it's simple enough. When someone takes confidential proprietary information, you may not see it immediately, but if you have a suspicion and you file a lawsuit or you send a letter, you can subpoena records. You can subpoena things from computers and text messages and emails and flash drives. So you can actually find out if someone did steal confidential proprietary things. Customer lists, pricing data, M&A strategy, all of that could be considered confidential, like their secret recipe for KFC or Coca-Cola, for example. But what we have seen, I think non-disclosure is a separate conversation, but we are seeing these contracts far more pervasive for American workers in every working class, from non-competes to non-solicits, non-disparagements, non-disclosures. And the FTC really focused their efforts on the non-compete. Occasionally, non-solicits can be considered de facto non-competes. And just to give you an example, a non-solicit stops you from reaching out. If your former customer or your former coworker said, hey, I want to come work with you, I want to do business with you, the non-solicit doesn't stop that. That's a third party who can do what they want. Sometimes I've seen non-solicits that say, oh, if you end up working with a competitor or working with my former customer, you can't do that anymore. So even if they reach out to you, you can't work with them. That's a non-compete. That would be banned. Now, for everyone who's kind of wondering, what happens next? Like, what is going to take place? So the U.S. Chamber of Commerce made a comment in the FTC's public comment section, and they said they were going to sue. And what happened is the day after the final rule was made, they sued. I have it right here. This is their lawsuit. They sued on the 24th. The rule came out the 23rd, and they are seeking to enjoin the rule, saying the FTC lacks the authority. It's a thing called the major questions doctrine. Won't get into that. Yeah. But what we know will happen is in about a month or 2 months, that court in Texas will make a rule, and they'll decide if this thing has the authority or not. They might ban the rule. They may allow it. No matter what happens, the losing side will appeal. They will appeal this to the Fifth Circuit Court of Appeals. Yeah. No matter what happens at the Fifth Circuit Court of Appeals, who wins, who loses, it doesn't matter. The loser will appeal to the United States Supreme Court. And the Supreme Court of the United States does not have to take the case. That's not a requirement. But I'm very interested to think that they probably will. The idea of federal agency overreach is not new. You might remember this from a couple years ago when OSHA tried to mandate vaccinations. And people were like, why does OSHA have the authority to do that? And it went to the Supreme Court.
Shadow banned.
And it went to the Supreme Court. And the Supreme Court said, no, OSHA doesn't have that authority. So there is a real question. Now, what I really want people to avoid is cynicism. To think that all of this effort, all of these comments amount to nothing if it gets overturned is not the way to think about this. We are watching American workers participate in their democracy in a way they haven't in some time. And this is encouraging. There is other ways to ban non-competes, but the easiest thing to do is just don't sign them. Just don't sign them and you walk away. That's the best way to deal with non-competition agreements.
Why? Let me ask you this. Why is this considered a federal issue and not left at the states, considering there's already states who have already banned it? Do you think that the Supreme Court, for example, would be like, well, no, this is a state issue. All these states have already banned it, and then lobby the state. Do you can you break down why this is a federal?
Yeah. So the way to look at this, for people who want to look at the history, 100 years ago, we had things like child labor laws, and we had, we had hours of work when you get overtime. And these things, these wage and hour things were at the federal level, and the states were like, this is bananas. Why would you do, we do this? Why would you do this? Yeah. And this idea came out called the freedom of contract. The idea that you could enter into a contract with anybody as a business, and whatever the terms are, you're both bound by it. Yeah. And it took Delano Roosevelt threatening to stack the court and said, look, if you don't allow these very popular laws that I'm creating, I will put more justices in the Supreme Court. So this absolutely is a federal issue. The question we have to ask ourselves is, does the FTC, are they given authorization to do this? Because if Congress, and there's a bill in Congress right now for anyone who really cares about non-competes, the Workforce Mobility Act is in Congress. You can call your congressman, you can email them, you could write them. They will listen. There's an act that would ban non-competes in our Congress right now. But the answer is the FTC probably doesn't have the authority. Now, I would love for them to have the authority, but looking at our current Supreme Court, it's highly unlikely that they would say, yes, the FTC has the authority to step into 30 million contracts and invalidate them.
And again, and I've stated my opinion on non-competes numerous times. They're bullshit for anybody up to decision-making levels, right? Like any frontline worker out there, you should not be under a non-compete at all. But there is a certain level of information like we've discussed on here. But I also do not think that it's the federal government's duty to even step in, and especially the FTC or something like that. I truly feel like it's kind of a state issue at that point, because it's the local businesses that are affected by that and everything else. And, again, this is just my own personal opinion on a lot of this stuff. I'm not saying and again, abundantly clear, I think non-competes are bogus for the majority, but I also think that it shouldn't, the FTC, just like other government agencies, shouldn't dictate what a state, decision should be made.
Yeah, what I hope happens here is that businesses reevaluate why they use them.
Yeah.
So if I'm a business, why would I use a non-compete? One, maybe to make sure I don't have people compete with me. That's the clear thing. But it's a way to drive retention. You won't leave me if you can't do your job anymore. There's this idea that I think is starting to catch a lot of ground here, is that if you're a company that values diversity, equity, and inclusion, you need to reevaluate why you have the non-compete, because what these things functionally do is prevent entrepreneurism. They disproportionately impact people of color and women, for sure, in terms of the negotiation process. And if you're a business and you're so concerned about people going off and competing with you, you sound a little bit fragile. Like this industry, this world we live in the United States, almost every worker is at will, which means you can use your job for any reason. If you're laid off and you have a non-compete, you're still bound by the non-compete. So like these things are very dangerous. The goal that I would have, and I think FTC could do this, this is a rule they should think about, is mandate every job description that's posted requires disclosure that there's going to be a non-compete. Because I think that would show people, hey, I don't have to sign this. I don't want to even talk to this company. That's a much more useful path than the let's ban everything across the country and let the states, just override them entirely.
And I'm right there with you, right? Because I feel like there's always going to be that gray area, right? Because that's what fucking attorneys do. They find the gray area in this, right? Like, because some attorney out there, maybe not the armchair attorney, but some attorney out there is going to find the gray area that's going to stick somebody to it. But, like you said about being laid off, if you're laid off, you should not be bound to a non-compete.
Of course, of course.
Stuff like that. There needs to be an unwinding of a lot of this, but I think that having a disclosure on the job posting, this job requires a non-compete, and then maybe even list what it is, a 1-year non-compete, a 2-year non-compete, something like that. I think that that's fair, because again, I just think you should know what you sign. I think that maybe there should be some, and this, because to me, this is the biggest red flag of it all. If you are ever signing any employment documents at all, I think it's a massive red flag if they do not allow you to leave and review it at your home and speak to your attorney or something like that. Because again, as a business owner, I can say that I won't have non-competes in certain areas of my business, but there will be certain ones that will be enforceable, but I also think at that time, it will be hey, maybe go talk to an attorney about this and see, is this something that you want to do? I think some businesses should spend more attention, pay more attention on doing the right thing, right? Because I feel like as an employee, if I was an employee, that would be the right thing. I would want somebody to be like, no, take these documents, go read them at home, go into your comfort area, and then come back and sign them if you'd like.
Yeah, I would agree with that. I just got a couple of caveats. So Illinois does a pretty interesting thing as a state. So what we do in Illinois is you must be given 14 days to review the document, a non-compete or a non-solicit. You are encouraged, and actually in the contract itself, it must say you must go seek outside counsel. And it also bans them for people under a certain income bracket. So the reality is 30 or 40% of all non-competes are with workers earning under $20 an hour. So these are people that really ought not to have any non-compete, but they end up having them because that's the way the business is structured. I would say this though, Chris, half of America, if they had to come up with $400 in 24 hours, they couldn't do it. So if you're asking people to sign a contractual thing that's been drafted by lawyers, the people looking for the job may not have the time, the network, or the money to afford an attorney. This is why I find these post-employment restrictive covenants so problematic. In the C-suite, when you get a non-compete, generally speaking, they pay you the entire time that you're sitting out. In every other worker's case, they do not do that. And if you look at sorry, go ahead.
No, I was going to say, so would you, and I'm not trying to corner you or anything, would if it comes down to it where they're no, non-competes are still going to be enforceable, but you have to pay the employee their hourly or salary for the 3 months or the 6 months?
Absolutely.
Yeah.
Absolutely. And businesses couldn't afford it. The reality is the way that businesses talk about non-competes is we are trying to protect our business interests. We're trying to insulate ourselves from competition. And you, the worker, you're super dangerous, but I'm not going to pay you because I really don't value your time that way. I just want to make sure you don't compete with me. It's this idea of the fragility of American companies that rely on non-competes for every single worker they have. I mean, Jimmy John's got litigated against, they took theirs away, but a lot of companies you wouldn't expect have non-competes, like dog grooming companies or personal design companies. They're everywhere. And so for me, if you're required to pay out the entire amount you ask the person to sit out, the companies, all of them would stop using them. Every single one would stop using them. And that's why you're not going to see that happen. But I would love for that to be a requirement of the non-compete.
I think it's going to be an interesting evolution of because especially if, say it gets down to it where they're like, hey, you know what? It's the state's decision to make. We're not going to see this. Because like you said, I mean, the current sitting of the Supreme Court probably will not allow the FTC.
Oh, they will not. There's no way. They would look at me and say, this is an unconstitutional delegation of congressional authority. We are not going to allow it. Absolutely.
Which I don't necessarily disagree with at the end of the day, right? I think that if it's going to be a state thing, then I think that this is, because like to me, this is how the United States is supposed to be designed, right? Where it's like, hey, you know what? If you don't want to, like there's always like, go live in a different state potentially, or whatever that looks like, right? Like the right is there. Nobody's stopping you from doing that. And I think like there are just certain issues out there that, again, is it then, I look at it like this, Matt. So say, because I'm just trying to speak in like transportation sense here, considering there's a lot of companies like, that are headquartered in Illinois, or they're headquartered in Minnesota or California, but they have offices all throughout the United States of America. Then could you challenge, like, say it gets down to the point where they're like, no, it's a state issue, we're not going to hear this. Say you're employed by a company that's headquartered in Minnesota where non-competes are unenforceable, but you're working in a branch in, say, Arkansas where non-competes are enforceable for whatever reason. Who supersedes what? Is it where the company's headquartered at, or how does that look?
So each contract is going to have what they call a choice of law clause. So it's the choice of law will say we might be based in Minnesota, but the law we're going to apply is Delaware, or law we're going to apply is Ohio. There's a 3-letter word, the broker that uses Ohio for all their non-competes.
Which one?
I think it's TQL. But what I'll tell you this is the reality is non-competes are among the most un-American contracts that I have ever seen. And that is absolutely true. We, as America, encourage entrepreneurism. We encourage people to create businesses and to find ways to provide a better life for your family. And for a business to come to you and say, we're going to stop you from doing it with no time to review the document ahead of time, no money to get a lawyer to do it. I mean, this is why these things are so dangerous. Now, Chris, the other thing I'll mention is not all of these things are litigated. What typically happens in a non-compete type of action is you, the former company, send a cease and desist letter to 2 individuals or 2 entities. 1, the former worker, and 2, the new company they're working for. And when that new company receives that letter, they fire you. That's what they do. So this is not like, oh, we're going to go to district court and litigate this. No, this is, we're going to ruin your life. And if you fight us, we'll break you. And that's what those comments on the FTC's website really highlighted was, why is it that there's medical deserts in this country where you go out to a rural area and you can't find a doctor? Because the doctors at the hospital in that county sign a non-compete. And if they go work for a smaller hospital or smaller practice within 20 miles, they get sued. So they leave the market and go to a major metro area. So we see bad outcomes for healthcare practitioners because of non-competes. So ultimately, these things will end, whether it's the FTC, whether it's Congress, whether it's Americans making decisions not to support companies that use non-competes, they will end. And I am so excited to see that happen someday.
Dude, I love how passionate you can get about some of these things. If you can't tell, Matt's a major proponent of non-compete.
I love them. I love restricting people from doing what they're good at. That's the best thing in the world.
But I think because I think say it does get rolled, where they're like, hey, non-competes are banned. They are done. What is the next thing? Because I always like to think ahead on shit, man. Like, I don't like to think present. I like to think what's next. I like to think the next 12, 24 months. That's how my brain works. So inevitably, if non-competes get banned, what's the next document that comes up that would be applied to stop people from doing certain things?
I think the ones I would be looking at after non-competes would be non-solicits and training repayment agreement plans. So a training repayment agreement plan, or a TRAP, is designed to, when you train somebody and you say, hey, I taught you how to be a good dog groomer. You owe me $5,000 when you quit. It's another type of employment control. So I think traps are going to be in jeopardy. And I also think the non-solicits ultimately will be targeted. Now, not maybe at the FTC level, but certainly at local states. And that's what Illinois has done. Other states have kind of said, we look at non-competes and non-solicits very similarly, because the way you enforce a non-solicit is the exact same way you enforce a non-compete. It's a cease and desist letter, it's automatic termination, or it's protracted litigation. And it's very expensive. I've had plenty of friends that have been sued for these things, and it can be $10,000, $20,000, $30,000 a month to litigate. And that is not something most people can endure.
Yeah, the attorney in Matt loves $10,000, $20,000, $30,000 a month, but the employee advocate hates that. But no, I literally think that what you're going to naturally see is because I personally think non-solicits are way more damaging to an employee than a non-compete. I truly do, because at the end of the day, what's going to happen, Matt, and I've seen this from very large brokerages out there, is they'll have a non-solicit for carrier reps, and they can't work with certain trucking companies. And, then they have the non-competes or the non-solicits of customers as well. And then they can go and say, every single customer that our company is set up with, you cannot reach out to. Same with carriers. They can go on
and
every carrier.
That's an interesting point you bring up. So like one of the things we've seen with non-solicits, this varies state to state. If you think you need an attorney, you probably do. You should hire one. This is not intended for legal advice. But a lot of people who have a non-solicit that becomes enforceable is entities or people you had direct relationships with. Like you were directly working with these motor carriers or these shippers, and these expansive ones that say, we consider anybody who did business with us last 2 years as part of the non-solicitation. Those are likely not enforceable. Now, people still enforce them because it's a way our litigation system is designed, is that you can sue even if you might lose. And so I think we'll see some changes. The other thing is it's a lot easier to circumvent a non-solicitation agreement if you simply don't solicit. If you're good at what you do, your customers, your carriers will follow you. They will find you. I would say, again, seek legal advice, find counsel to make sure you're doing it right, but nothing restricts them from coming to you. It's about you reaching out to them.
So let's say this again. This is not legal advice by any stretch of the imagination, but say I use my personal cell phone for that work-related, information, and that's how all my communication via text, email, phone calls were all done on my cell phone that was owned by me. But, and here's the caveat, the company reimbursed me every month for my cell phone. Who owns that? Because that's another common tactic that's out there that I've seen people get pinged on. And that's why I want to bring this up right now, because there's people who are out there like, I use my own personal cell phone. I have all their contact information in there. But where's that line, Matt, if they reimburse you for your cell phone?
So that's, again, it's going to vary state to state, but generally speaking, the cell phone is yours. What can happen is presumably they can force you to delete things, and you might do that regardless. If they think you're violated your contract, they can subpoena your cell phone records. Like if you think you've deleted something, they can find it. Everything is discoverable. This is the stuff when I talk to people about like what is discovery, it's when they ask questions to you or to any other entity. So your cell phone provider, your computer provider, all this, they can ask for the documents, your social media records, and they'll get unredacted versions of those things. So if you think you're circumventing something because you deleted it on WhatsApp, you might be in trouble. But I'll end with this, Chris. Again, this is about taking rights from workers when they don't necessarily have to give those rights away, and they don't necessarily understand what those rights are. It is our job in this industry to educate people about what is a non-compete, what is a non-solicit, what are you being asked to give up? Because when you leave a job, not just your former employer is watching what you're doing, your new employer, the first thing they're going to ask you in every contract is going to be, what other post-employment restrictive covenants do you have currently in effect? And you must produce those to the new hiring entity. So we have made it so difficult in this industry and across America to be a working person. And the amount of business overreach into the personal lives and to the after they've stopped working for somebody, these are things we shouldn't be encouraging. I understand the non-disclosure. I have very few objections to a non-disclosure. A non-compete is un-American. It is for weak companies that are too fragile to compete in the marketplace of ideas. And non-solicits will be targeted eventually. But ultimately, if you can't retain your customers, try and be a better business. Don't try to be a litigator. Don't use the law as a tool to bludgeon your former coworkers. That's dumb. And it's obviously not something I'm a big fan of.
Matt Leffler, 2024, Lombard, Illinois.
I'll tell you something, Chris, I'm on record here. If we do not pass something that stops non-competition agreements, I will run for office as a single issue candidate. The only issue I care about is banning non-competition agreements. I don't care if I'm a Republican. I don't care if I'm a Democrat. I am here to stop very pernicious and pervasive post-employment restrictive covenants. I want them to go away.
And at that being said, I will also run as a single issue candidate and oppose everything Matt Leffler says
We're going to Washington, buddy. That would be a lot of fun. We'd have a good time. We'd have a great time.
Oh, man, I appreciate you, brother. Thank you so much for tuning in. And you guys, again, do your own research on this. I think at the end of the day, this is a topic that is going to be constantly evolving. Be careful about where you get information from. And always, you guys, do your own research, okay? At the end of the day, do your own research. Know what you're signing, because there are people out there with better attorneys than most people can afford who will fucking bury you, because that's what they're paid for to do. So just be aware, you guys, be diligent on what you're doing. And, just if something seems too good to be true, it probably is. But yeah, you guys, we'll be back tomorrow. We got another guest coming on. And yeah, as always, if you guys got value in what you heard, subscribe to the show, you guys. Share it out there to your network, because if you see value, your network will see value as well. I appreciate you guys. I love you guys. And we'll be talking to you soon.